later in the presentation if there's opportunities to ask questions aloud, but for the time being, please put your questions in the chat and we will try to get to as many as possible after Annette finishes her presentation. So please take it away, Annette.
Hey everybody, I am Annette Hines. I'm a local attorney here in Massachusetts, and I am a mom of 2 girls. And so I've been doing guardianship for more than 2 decades. I don't like to say that because it makes me feel super old. Along with that, we do a number of other advocacy types of work, as well as special needs and disability planning. I am not going to get into super detail about the guardianship process because I think what we really want to talk about today is that transition to the next generation of caregivers. And that's what I find most people really are challenged by when I talk to siblings. We really want to tackle, I think, some of the tough questions that come up when we are planning for, that next generation of caregivers. So I am going to kind of tackle this in 5 key topic areas. And I'm going to assume that you have some knowledge. If you don't, please go ahead and enter your questions in the chat and we'll see if we can get to them. First and foremost, we cannot start this conversation without talking about what's happening in our court system with COVID and life after COVID as we're transitioning out, because it has really been challenging to get through any kind of guardianship process over the last almost 15, 16 months. For anybody who has been trying to do a guardianship or a conservatorship case through the probate and family courts. What happened in March when COVID hit was the courts did shut down. And many of you may have experienced that if you've tried to have, have a case heard or to have any kind of a pleading or a care plan report or any kind of a matter that pertains to a guardianship be dealt with at all. The courts are open now for filings, but each court is handling things a little bit differently. And they are still doing non-emergency cases by Zoom and by telephonic hearings, depending on the judge and depending on the county. So, the hard thing, and this has always been the case in Massachusetts, is that county by county, the rules do differ a little bit. There hasn't been strong uniformity, and that has been the challenge for practitioners, but it has definitely been challenging for family members who are attempting to access justice in our court system, in the probate and family courts. Scheduling for cases has been extremely variable, and across the board, you can, in some counties, some judges' calendars, you can access a case in 4 to 6 weeks. In other judges' calendars and in other counties, you may be 6 to 7 months out trying to get heard. So you are, going to be catch as catch can, trying to figure out what direction you're going in. Do you have an emergency, or don't you have an emergency? What constitutes an emergency on a court by court basis is different. And because this has been exacerbated by the pandemic, people more than ever are feeling like things they could have managed on their own, they're not able to manage without counsel. So one thing that you should know is that there is a virtual registry now, which means that you can jump on Zoom and wait your turn and ask a question by getting face-to-face with somebody, at least electronically face-to-face with somebody. And that is helping a little bit. The information that you're getting is a little bit different from court to court, But I do find that they are really trying to help the public navigate some of these challenges that we've been having because of the pandemic. There are still many court personnel working from home. Not everybody has gone back to work in our courthouses. So they are still struggling themselves. And I do want to say, maybe have as much patience for them as they are trying to have for you. And hopefully we'll all get through this together. So that was just a little bit of, I hope, helpful information about how to manage something if you are trying to do this on your own right now. Okay, now getting into the meat of our talk today. So you've just been asked to step into some kind of a guardianship or a fiduciary role for a family member or a loved one in one way or another. This is going to be a decision-making role. Potentially it's your sibling or some other loved one. So now what? What happens next? What are the things that you need to consider? And let's kind of go down the list of things that you need to consider and what we should talk about. So first and foremost, is there already a guardianship in place? Because that is going to make a big difference. Believe it or not, many cases come into our office with somebody who is, 40, 50 years old, and there is not a guardianship in place, but probably should have been a long time ago. And informal supports, and many of you probably know what I mean by that. Informal supports have been in place for a long time. The medical personnel, the healthcare system, the financial system, the community supports have been allowing decision making to go on with parents or with, the parental nominees, if you will, but will no longer allow siblings to take on that role. They're just not comfortable with that next generation doing informal decision making. They are now going to require a court order. They're now going to require somebody to step in with that decree and order. They're going to, now require us to do a guardianship process or to look at, some other fiduciary support, but in a more formal way. And so now we're in a different place. And so this happens a lot. It's starting to, get to be less and less, but we still see this, in a significant way. And I would say that, a case probably walks into our office still like once a week. So if there's already a guardianship in place, we need to look at next step. Are we adding a guardian to someone who's already there? Or are guardians stepping down? So do we have a parent who is just not able to continue on? Do we have a parent who is diminished capacity, who is not making a decision to step aside? Or do we have no guardians because somebody has passed away? So that's if we have a guardianship in place already. And then we're going to go down a different path if that's the case. If we have no guardianship at all, then we need to potentially look at and start a fresh guardianship. If we have an old guardianship, we've got to look at that old guardianship that was potentially in place before our Massachusetts Uniform Probate Code went into effect. And that was in 2009. Because we were under different rules back then, many, many times under those old guardianships, you will see a decree and order that had both a guardianship of the person and a guardianship of the estate. After 2009, we've what we call bifurcated, or we've separated out those two duties, financial and personal decision making. And so if we're going in to change any guardianship duties or change over the guardians, we're going to have to address that issue. So I'm going to go over those things as well. Okay. So the next thing that we need to think about is, are there any documents in place, any estate planning documents in place that talk about a preference for who takes over as guardian? Have the parents nominated a successor guardian in their estate planning? Or has the individual themselves nominated somebody who they prefer as their guardian? Because there is a priority of appointment in our state statute for who gets to be guardian. And in that same vein, can our respondent, can our disabled person express a preference for themselves over who they want to be their guardian? And then the last consideration before we jump in and talk about this really big area of considerations is there money involved that we need to plan for? So sometimes when we have somebody walk into our office and there's never been a guardianship, we also are looking at the death of a parent. So it's not just a guardianship, but we're also doing some estate planning too, because they not only have never done guardianship, but they've also never done estate planning. There's, a back Social Security payment. And many of you, if your siblings, may have gone through all of this with your parents who've passed away. There's a big, there's a will, there's no trust, no special needs trust that's been put into place. There's just a lot of loose pieces here. And there's a lot to do. So we may need to not just do a guardianship, but we may be putting a special needs trust in place. We may need to go to court to ask special financial permission to do certain things. And we want to go to court and seek authority over every decision at the same time. So we want to take a look at all of those things at once. So those are all the things that we need to consider. What fiduciary and decision-making roles are we looking at? Sort of the whole picture. Okay, so I'm going to back up a minute and just kind of pick apart these knots. And what I want to really focus in on is that decision point between, was there a guardianship in place before, and was there never a guardianship in place? Because that's the point many people find themselves at. So if there was never a guardianship in place before, one of the things that we really need to look at is, do I need a guardianship or not? And we're going to talk about some alternatives to guardianships in a few minutes. But if your answer is yes, I need a guardianship because the informal supports really weren't adequate, even though they were working kind of, sort of, but we really know that we need a guardianship. And we're going to go forward on that basis. I think that, that's pretty obvious to most family members that they do need to go forward with the guardianship. I think that, that's a little bit more straightforward with the petitioning process. The most important thing to know in that perspective is who should be the nominee, who should be the guardian at that point, and how do you figure that out? So you're going to be looking at those preferences. Can the respondent or the disabled person, who is we call them the respondent, can they express a preference themselves? Because the court is going to want to know if they have a preference and who serves in that role for them. And is the parent available to express a preference? Because they're going to be next on the priority list. If neither of those is available to express those preferences, is there any documentation of either of those preferences? And what does that documentation look like? That can be done in a will by a parent, or it can be done in a nomination form under our state law as well. So you might want to look to your parents' estate planning to see if they've ever done any kind of a nomination for guardianship for their disabled adult child. So that would be important to check on. If your sibling has ever done a power of attorney for themselves, their personal nomination might be in that form. They would have had capacity in order to sign that power of attorney. So if you're going for a guardianship at this time, it's a little tricky to think that they might have had capacity at some point to sign a power of attorney, but they don't have capacity now. It's possible, could be that that's the case for some people, but maybe not. Something to think about. So if there is some writing that expresses that nomination, that's great. If not, then the next choice is obviously who steps forward and is willing and who can serve in that role. Now, if there is a guardianship in place, it's important to note that even if you are stepping in as a new co-guardian to somebody who is already there, you actually, under our state law, have to terminate the old guardianship and petition for a new guardianship, which is a super pain in the butt. And is not super intuitive. You would think that it would be easy and make more sense to continue on historically the case that you already have open and just add a new person to that case. But that's not how it works. We actually have to do two court cases. We have to terminate the old guardianship and open a new guardianship with the new person and the old guardian who is still serving. So it's a lot of work. We also have to get new medical documentation, even if that is a new clinical team report. And we're going to go through a quick review of the guardianship process in about 3 minutes when we get to that point. So we'll talk about what that medical documentation is. So many people don't understand that you do have to go through this whole new petitioning process. And they think that seems intuitively like it should be, somewhat easy to just add somebody to their guardianship. But it is not easy. It's a whole new petition, whole new process. And again, you want to think about whether you've got an old guardianship that includes financial authority, because if you do, you are looking at a pretty challenging closure, because if you had financial authority, the court's going to be looking for some reporting of that old financial authority as well. So passing the baton to the next generation for guardianship can be somewhat challenging, but the sooner you do it, the better. And if you can do it while parents are still alive and helpful, that can actually be better. Because if there is reporting to be done, you may want to have them around to be able to help with any financial reporting that needs to happen. Now, the courts can be somewhat sympathetic about that, but not completely sympathetic. They still require what the law requires. Okay, so let's see. Let's go to part 3 of our presentation and do a quick review of the 3 phases of the guardianship process so we can understand a little bit about what that looks like. So our guardianship process is made up of the petitioning phase, the notice phase, and then your hearing phase. The petitioning phase is basically, what are you asking for? Call this your pleading phase. You're pleading to the court. You're asking them for the court to do something. And in your petition, you have to ask the court for what you want, and then you have to provide the court with your evidence as to why they should do what you're asking for. And your evidence is your medical documentation. So that is either going to be a clinical team report for somebody who is intellectually disabled, or it's going to be a medical certificate for everybody else. And even if you've got an ongoing guardianship, as I mentioned in our last segment, you have to provide that medical documentation all over again every time you make a change to the guardianship. So if you are adding somebody to your guardianship, or you're terminating your guardianship, which we're going to talk about in our next segment, you still need to have that conversation with the medical evidence about why this is appropriate. Because you have to have proof. This is a court case, it's a hearing, and you are doing something to another person's freedom, potentially. It may feel different because it's your family member and you're aligned with what's in their best interest. But we can't lose sight of the fact that every step that we take in guardianship court diminishes their freedom to make a decision for themselves. Whether it's about where they live, what they eat, where they go, where they work, who they associate with, whether they get to drive, anything, whether they stay home alone, we have to keep that top of mind. This case is a case against somebody. So as much as we know that we are aligned with our family member, we still are in a case that has an opposing party, and that opposing party is our family member. So we have to remember that the judge is there to protect their rights, protect our family members' rights, and make sure that everything is done properly. And we have to provide the evidence to prove that what we're asking for is appropriate for our family member. And remember that if it wasn't us and it was some random person who was petitioning to make these decisions for our family member, we would want them to have to prove that this was necessary, right? Take yourself out of the picture and put some random government official in there or some random agency person in there. And then remember that you would want the judge to be reviewing this with a fine-tooth comb. You would want somebody looking over everything carefully. And I think that puts a different spin on it. Okay, so having said that, back to the evidence. Your evidence needs to prove that you need exactly what you're petitioning for. So if you're asking the judge for a limited guardianship over X, Y, and Z, then your medical documentation proves that your person cannot make decisions for X, Y, and Z. So healthcare, where to live, whether they can drive or not, whatever the decisions are that you are claiming they need assistance with, the medical certificate or the clinical team report needs to match up with that, what you are claiming in your petition. Simple and straightforward, right? So petition and medical documentation. And even if you are terminating a guardianship or limiting the guardianship further, whatever you are doing, you need to make sure that the evidence matches up. Now, if you are just simply adding a guardian in, you still need to continue to have the same claim. So you're still saying my person still needs the same guardianship protections. So I still have the same disabilities and the same issues going on, okay? Once the petition opens up the case and starts the matter going forward, you're going to get to the second phase, which is the notice phase. You have to put all interested parties on notice. And I find that this is the area where most people get confused about what needs to happen next. Notice goes out from the court, and that's an order to the petitioner to give notice to the interested parties, but they don't tell you who the interested parties are. They kind of give you a hint about who the interested parties are in this piece of paper called the citation. That's your order of notice. And it says that you're supposed to give notice to the interested parties. In your petition, you list out who you think the interested parties are. You list out from the top of the list, it tells you who you're supposed to put on that petition. You're supposed to put the siblings, the parents, and it gives you the order of people that are supposed to go on there. But it can be a little confusing who some of those categories are. So sometimes you can need a little bit of help. But in general, it is the people who have care and custody, but not somebody in the group home, for example, and not somebody in a nursing home. It's, you know, it's if they're living at home with their family, that would be a person who has care and custody. Somebody who's living with them and hands-on taking care of them, and it's their family member. A representative payee, a current guardian, somebody who's healthcare proxy. So it's people who have a legal obligation to them, pretty much. And then you'll go down the list and you'll see who needs to be on there. When you get that order of notice, you have a very quick turnaround time. It's usually less than 10 days to get that notice out. You have to give the notice in hand to the respondent. That's the disabled person who the case is about. And then everybody else, you can mail it to them, first class mail, unless they live out of state, in which case you have to do certified mail. And this is all listed in the statute, but you would have to know to look it up in the statute to understand how you have to give notice to everybody. Or you can put it in the newspaper. A lot of people think that they have to put it in the newspaper. You don't have to put it in the newspaper unless you don't know how to find people. So you really don't have to put it in the newspaper, and you probably shouldn't, because nobody wants to have their business out in the newspaper if they don't need to. It's also really expensive. It's $300 to $400 to do a newspaper ad these days for a legal notice. So it's pretty expensive. The next thing is, as soon as you pass that date for giving notice, then, and that's called the return date, and it's listed in bold right on that citation, then you're able to call and get your hearing date. And you can return your order of notice where you sign and prove that you've given notice to all of the interested parties in your case. And now you can get your hearing date. And that's where you've got this huge, huge disparity. Like in Barnstable, I can get a hearing in 3 to 4 weeks. And in Middlesex, depending on the judge, I might be 7 months waiting for a hearing. And these are all on a guardianship case. And it can vary from judge to judge to judge, depending on their trial calendar. If you have an emergency, you can make a motion to try to get heard sooner. You can do temporary guardianships if you need to get in and get, a temporary, and there's lots of different things that can be done, but you kind of need to know how to maneuver through the court to get all of that done. And if you've got those kinds of things going on, you're probably going to need to seek help from an attorney to be able to maneuver through the court. I will say that I do think the court really, really tries to help pro se litigants. So jump on that virtual registry, tell them what you've got going on, and see if they can get you the forms that you need, and try to help you get what you need going on. And I have complete sympathy. Not everybody can afford an attorney, and a lot of people manage quite well without having to hire counsel. So I know the courts really are trying to help people have access to justice right now. Okay. Once you get your decree, when you get to your hearing day, like I said, everything is virtual still, and you're either having a Zoom hearing or a telephonic hearing. And the wait times have varied to anywhere up to an hour and a half in the waiting room. You're sitting in a Zoom waiting room for your turn for the most part. But the hearings themselves are only taking 5 to 10 minutes, and they're very straightforward. So it's been fairly innocuous. I mean, it's been very, very easy to manage. And other than a few little technical hiccups here and there, I think that they have been much smoother than actually trooping into any of the courthouses, with the occasional problems with having to upload forms. I think this has been a blessing. I think that we've got some virtual hearings are here to stay. And I think that, you know, we are probably evolving into some kind of a hybrid system with moving forward with some virtual hearings ongoing. Ongoing requirements are, you know, very basic for a guardianship that does not have Rogers authority, which I'm going to mention briefly. You have a care plan report that needs to get filed every year on the anniversary date. And if you are a new guardian and it's a new guardianship, you have to file one within the first 60 days. So if it's a brand new guardianship, you have to file a care plan report in the first 60 days and then every year on the anniversary date. The care plan reports are easy. You can find them online. All of the forms are online at the Massachusetts Probate and Family Court website. They're all fillable forms that you can save to your computer on PDF, and you can refill them and save them year after year. So they are easy. And the care plan reports are just asking you questions about what's been going on with your person. You don't need legal help to do them. And then you just mail them or give them in hand to your person. And then you send them into the court when you're done serving them to your person, you just mail them into the court. I do recommend anytime you send something to the court that you send it certified mail, because they do lose things, misplace things, and then you will get a nasty gram that says you haven't filed your form, and you know you did. So having the proof that you've sent it to them can be very helpful. I recommend doing that with Mass Health, Social Security, DDS, any state agency that you work with. It has served us well through the years, through the decades, time and time and time again. Proof of mailing is very helpful. We actually keep a mail log here in addition to proof of mailing of everything that we do. And it is just enormously helpful. Okay, a brief minute about Rogers authority. So a Rogers treatment plan is for antipsychotic medications, and that's to do substitute judgment for somebody who needs these antipsychotic medications. That is going to require counsel to be appointed for the respondent, and that requires extra authority and a Rogers monitor to be appointed, which is usually the same as the guardian. It's a little more than we can go into today, but you know, you should note that when your person, your respondent, gets counsel appointed for them, it's probably a good idea that at least the first time that you're going to be guardian, you might want to think about getting counsel for yourself that first year, at least to have a consultation so you understand what your responsibilities are, even if you don't have ongoing consultation every year. If the Department of Mental Health is involved, their lawyers are phenomenal. They pick up a lot of the work every year for ongoing reviews, and generally we have a really good relationship with them. The DDS lawyers are phenomenal too, but DMH generally is involved when it comes to those Rogers reviews, and I highly recommend working closely with the DMH attorneys. But I do think it's very helpful for people the first year that they become the guardians to get familiar with what their responsibilities are when it comes to these antipsychotic medication treatment plans. Okay, alternatives to guardianship. So sometimes it's a really good idea to ask yourself, as you are sort of taking over and stepping into this role, where you've looked at Is there a guardianship? Is there not a guardianship in place? Do I need a guardianship? What are we looking at here? Let's get our arms around this. What are my alternatives to guardianship? Even if there is a guardianship in place, sometimes we can look at terminating a guardianship, because back in the day, guardianships were done pro forma, and we weren't thinking about them the same way we think about them today. No judgment about that, no pun intended. But we have a different framework today that we're thinking about independence and self-determination, and that's a good thing. So what are our alternatives? Healthcare proxies for healthcare decision-making, HIPAA releases, durable powers of attorney. And on the financial side, ABLE accounts, special needs trusts, being a rep payee under Social Security payments, Mass Health authorized representative designees, and permission to share forms for Mass Health. And that leads us to thinking about supported decision-making, and should I close a guardianship if there is one in place? So I wanted to close out my talk today by thinking about this question, and whether we should even do a guardianship if we don't have one, and whether we should close a guardianship if we do have one, or further limit a guardianship. So healthcare proxies are springing in nature. And if you don't have one for yourself, every adult should have a healthcare proxy. It's really important, and a HIPAA release. Healthcare proxies come into play not for day-to-day decision-making, but when you think about that coma situation, right? Or an older person as dementia sets in. They are springing powers when something happens and you can no longer make your decisions, and only your doctor decides when you don't have capacity to make any decisions or a specific decision. There's a very low bar for being able to sign a healthcare proxy. You only really need to understand that somebody will be making healthcare decisions for you, and that you want X person to be the person to do it. So when you are able to sign a healthcare proxy and put that in place, it's in your medical record, and then it's sprung into play when a doctor decides that you need it. So for example, I went to see my doctor for my annual physical yesterday, and as part of my review, the nurse practitioner said to me, "Hey, do we have a healthcare proxy on record for you?" And I'm like, "Yep, it's my husband." Click, 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 checked. Oh, yep, there it is. It's in the record. It's not in effect right now because I'm still making all my own medical decisions, but there it is. It's in the record. It's my husband, et cetera, et cetera. So if I had a heart attack tomorrow, knock on wood, and I was in the hospital, it's there, it's in my record. The doctor invokes it, and my husband's able to make my decisions for me. HIPAA release is a medical records release, which allows sharing of information, but not decision-making. Anybody can sign one of those as well. It's a very low bar, and those are great sharing of information forms. They're just releases, basically, for medical information. So really good documents for that can help if you are thinking about alternatives to guardianship. Powers of attorney, durable powers of attorney, are for financial decision-making, and those are concurrent authority. So that means that you can have your person sign one, and you can currently work with them to do banking and to do financial decision-making and help them with contracts, et cetera. Much higher bar than a healthcare proxy They need to understand a little bit more about the authority that they are giving away, but it's not a springing power, which means that they can change their mind at any time, and they can, take that power away. However, it's not a protective power, which means that they still, they trump you anytime that they want to make a decision that you might not like. So they can give away all their money and they can make as many dumb decisions as they want. So it is not a protective document, okay? But you can use it to help somebody in their life. And sometimes that's all they need. So this may be a great alternative to a conservatorship over financial powers, which is highly difficult to run and very expensive through the courts. So, and special needs trusts and ABLE accounts are, really good estate planning tools that can be used for long-term planning. Rep payees for SSA payments are very helpful alternatives to guardianships and conservatorships, and for managing small amounts of money. And also being an ARD and a PSI for sharing information with MassHealth is a great way, again, to avoid a guardianship. And you don't need to be a legal guardian in order to be a PSI ARD for MassHealth. And you don't need to be a legal guardian in order to be a rep payee for SSA. So these are all possibilities for avoiding guardianship if you don't need that level of authority. Now, I'm a firm believer in guardianship when it's necessary, and limited guardianship if you need some legal authority, but not full legal authority. But it's also really good to think it through. So I want to also talk about supported decision-making, because Senator Lovely has put forward for the second year in a row a supported decision-making statute that may pass this year, and may take another year or two in its iteration to go through. Many states have now got supported decision-making, and it widely varies, and it's a wonderful thing to think about. We have to be thoughtful about how we use it. It's an alternative to guardianship, but it is not for everybody. And I wanted to just, kind of put this out for a minute or two, and then I think it might be another good topic later on this year to bring forward and discuss. But supported decision-making, if you think about it this way, it's a group of informal supports, and it's a contract that goes into place. It does not take the place of a healthcare proxy, a power of attorney, and HIPAA. You can have all of those things and still have a supported decision-making contract, and you probably should still have all of those things and a supported decision-making contract. The thing about the supported decision-making contract that makes it unique is that the individual hires the supporters, chooses the supporters, brings the people into their network, decides what things they need support with, seeks the support over those certain things, and then listens to the advice, and then decides whether they want to take the advice or not. So that's the difference, really. Because in guardianship, under the law, a guardian must take into consideration what the respondent wants, what your person wants. So you can't make decisions for somebody that you want them to have. You have to make the decisions that they would want. You have to do that under the law. But with a supported decision-making contract, the supported person makes all the decisions. It's just like me saying to my group of friends, what do you think about XYZ? I listen to all of you, and then I decide what I want to do with that advice. This is the same thing. And you can discard the advice if you don't want to follow it. So essentially, that I know I'm kind of making this very simplistic, but that is really the difference between supported decision making contracts and where a healthcare proxy, which springs into effect, and then, the healthcare agent is making decisions and the principal is no longer making decisions. So that's an either or. And with a power of attorney, both people can make decisions and both people can act. And with a supported decision-making contract, it's still the supported person who is doing everything for themselves. And the supporters are really just offering the advice and, taking the direction. So it's really a different role there. They're in that role of being that informal support that we have now, but we are asking our legislature to put some arms around it and to make it a little bit more formal than what we have now in an informal way. And some states have done this so that they can protect banking and finance and healthcare organizations to encourage them to allow supporters into the conversation. So I'm going to stop there. So we have like 5 to 10 minutes to take some questions.
Thanks, Annette. That was great. I know we could probably go on for a couple more hours, but we had, just pulling up the chat.